Laurel Legal Services presents What is Custody? This presentation provides general information and is not legal advice. This presentation will provide general information regarding custody, including who can file for custody and the different kinds of custody arrangements. What is the difference between legal and physical custody? Legal custody is who is responsible for making educational, medical, and religious decisions about the child, which can be shared 50-50 between parents, while physical custody is who has the right to physically have the child at any given time, which can be divided into a variety of arrangements. Primary custody involves one parent having the child for a majority of the time, while the other has partial, meaning they have the child for a minority of the time. Shared custody means both parents or guardians have physical custody of the child for an equal amount of time, while sole custody includes only one parent having physical custody of the child. Sole custody is a rare situation because it is in the best interest of the child to have contact with both parents. It is often ordered only in extreme circumstances and at the judge's discretion. If the other party is seeking time with their child, it is likely they will receive some duration of time. If there is no custody order, both parents have equal right to custody and either can lawfully take physical possession of the child at any time. However, taking the child away without the other parent's consent can be held against you in court if the action was not reasonable. Parents can work out their own custody agreement, but if they are unable to, most communities offer mediation services and counseling to help. Either parent may also go to an attorney to help, and if that does not work, custody may have to be decided by the court. An advantage of a court-ordered custody agreement is that the court can force the parties to follow it. If the custody matter goes to court, the judge must consider all 16 of these factors. Which party is most likely to encourage continuing contact with the other party, present and past abuse by other party or household members, parental duties performed by each party on behalf of the child, need for stability, continuity in the child's education, family life, and community, availability of extended family, the well-reasoned preference of the child, any attempts of the parent to turn the child against the other parent, the proximity of the residences of the parties, level of conflict between parties and willingness to cooperate, mental and physical condition of a party member or their household, history of drug or alcohol abuse by the party or their household members, the child's sibling relationships, which party is more likely to maintain a loving and nurturing relationship with the child adequate for the child's emotional needs, which party is more likely to attend to physical, emotional, developmental, educational, and special needs of the child, each party's availability to care for the child or make appropriate arrangements, and any other factors relevant to the individual case. Can grandparents file for custody? Grandparents can ask for supervised physical custody or partial physical custody if the child has lived with them for a period of 12 months or more, and if the action is filed within 6 months of removal, the parent to whom they are related to has died, or the parents are separated at least 6 months. Grandparents and other third parties can ask the court for physical or legal custody of a child if the relationship began with the consent of a parent or under a court order, and the party filing assumes or is willing to assume responsibility for the child, and one of the following conditions is met. The child resided with the grandparents for at least 12 months and is removed from home by parents if grandparents file for custody within 6 months of removal. The child is at risk because of abuse, neglect, drug or alcohol abuse, or mental illness on part of the parents, or the child is dependent. What if someone violates the custody order? The violating party may be subject to contempt charges. A motion may be filed asking the court to enforce the order, and once it's filed and the other party is served, a hearing will be set before a judge. If held in contempt of court, the individual may be forced to pay fines, attend classes, or have changes made to their custody agreement. Thanks for watching, and be sure to check out our other videos on other legal topics.